Civil Judge, Junior Division and Law Examinations. Law of Evidence Summary in English language is the topic for discussion today. Dear student friends, you know we are studying the Indian Evidence Act 1872 for the purpose of law of evidence. However, the government of India has passed a new enactment titled the Bharatiya Sakshya Adhiniyam 2023, replacing the old enactment, the Indian Evidence Act 1872. Since this new enactment, the Bharatiya Sakshya Adhiniyam 2023 has been passed in the middle of the academic year, almost all the educational institutions, that is centers of legal education, are following the old enactment. In view of certain practical constraints, the old enactment is being followed by certain authorities. Since it will take some time for the successful implementation of this new enactment, the Bharatiya Sakshya Adhiniyam. Therefore, we have to follow the old enactment, the Indian Evidence Act 1872. When any enactment is repealed and replaced by new enactment, we need not worry, because most of the contents in old enactment will be repeated in the new enactment with different section numbers. We witnessed previously when the Indian Companies Act 1956 was recodified in the year 2013, and Motor Vehicles Act in 1988, Consumer Protection Act recently, like this. So when an old act is replaced by a new act, most of the provisions of the old act will continue. Accordingly, in the three criminal enactments, namely Law of Indian Evidence Act, Indian Penal Code and Criminal Procedure Code, have been replaced by new enactment. However, it will take some time to overshadow the practical constraints. So that is why all judicial services examination and LLB examinations in respect of these three subjects are being conducted according to the old enactment. So in this lecture, I wish to enlighten you in brief whole subject of law of evidence. 2 days back, I uploaded this summary of Evidence Act in Telugu language. Today, I am uploading this lecture in English language. Strictly speaking, English language need not be mentioned, dear friends. Almost all the lectures in the first instance must be in English only, for the benefit of our Telugu speaking students in two states. I started uploading lectures in Telugu language recently. So let us come to this subject. In the law relating to the evidence is governed by Indian Evidence Act 1872, Act number 1 of 1872. More than 250 years elapsed since the passing of this act. So today I will enlighten you in brief about this entire enactment by discussing in the following way. Number 1, introduction. Number 2, scheme of the act. Number 3, section wise, topic wise and part wise in brief. From the beginning of this enactment to till date, I will give you introduction, and then I will take up this Indian Evidence Act contains 167 sections divided into 11 chapters. These 11 chapters have been divided into three parts. So, when since most of the topics are repeated in the new enactment, so what is the difference between old enactment and present new enactment? The comparative study, a lecture I will deliver one day, shortly. For time being, you are advised to follow this old enactment because time it requires lot of time. Please have patient hearing. I know you just upload my lecture in just 5 minutes, and thereafter you can watch my lecture. I understand the difficulty of my lectures, lengthy lectures 1 hour and above, dear friends. Unless I take 1 hour, I won't be able to complete the bulky volumable number of subjects. That is why invariably I am constrained to upload lengthy lectures. If I give small lectures of 10 minutes, the number of lectures will be in thousands, and you will be at a lot of confusion, dear friends. Now, let us give brief touch of this history, historical background. Followed all these things I will explain. Uh, um, Please have extend your patient hearing. Actually, we have three periods: ancient Hindu law period, ancient Muslim law period, and British period. This the seeds of law of evidence were sown in ancient Hindu period during Vedic period. During ancient Hindu law times, during Vedic period, the seeds of law of evidence were sown. Then this law of evidence was acknowledged by Dharma Shastras in those days at the time of ascertaining, finding out truth from fact in issue. What is the fact? What is fact in issue? I will let you know. That means the seeds of the tree of law of evidence were sown during ancient Hindu period, and that is during Vedic period. It was acknowledged or accepted by the Dharma Shastras, so that with these seeds of evidence, principles of evidence soil were sown, it grew into big tree and supplied oxygen to various branch trees and plants of this corpus juris, that is the body of law. This is what I can describe about this particular law of evidence. This law of evidence is cornerstone or basis for every branch of law: parent law or central law, provincial law or local law. For all these even special laws everywhere, without evidence, no court, no judge will be able to deliver justice. This most important branch of law, so called the law of evidence, its seeds were sown during earliest ancient Hindu law period, that is Vedic period, acknowledged by Dharma Sutras, to find out the truth, to decide a particular issue, particular fact in issue. So, in other words, truth is nucleus, basis, heart of this particular concept, the principles of evidence. So that is this concept of truth was acknowledged in the following next period, Muhammadan law period. In Muhammadan law also acknowledged this particular truth to find out this particular law principles of law of evidence to find out truth in a judicial inquiry. In simple words, the law principles of law of evidence were accepted and acknowledged during the earliest period, that is ancient Hindu law period, followed by Muslim law period also. The principles of law of evidence were acknowledged, recognized to ascertain the truth, and finally to this is where the process of development started during just British period. What are the developments from British period to till date? I will explain in couple of minutes. This truth is sine qua non. Truth is sine qua non for deciding any particular case. That is why this concept, the truth is nucleus. How heart is very important for survival of human body. This truth is nucleus of the law of evidence. It was acknowledged in Hindu period, ancient Hindu period, ancient Muslim period, and also British period. In British period, prior to emergence of India high courts at Bombay, Delhi, and Calcutta, there were dual system of courts. Provincial crown courts were functioning in presidencies: Bombay, Madras, Delhi, Madras, Calcutta, Bombay. Provincials were applied in Bengal, Bihar, and Orissa. The crown laws followed, crown courts followed principles of evidence, while the the Governor General Council courts did not follow the principles of evidence, resulting in conflicts. So that was why in the year 1835 an act was passed to take initiative for codifying the law of evidence. It was failed. Subsequently, 10 legislations were passed. All the 10 legislations were not fructified to codify this branch of law. And later, in the year 1858, when earlier the Governor of Bengal was redesignated as Governor General of India, Governor General Council of India. In 1858, the Governor General and Council has been redesignated as Viceroy and Council. And at the time, the real beginning of codification process was started. First, 1835 Act failed. 10 enactments followed. All the 10 enactments failed. In 1868, the Third Law Commission, in its fifth report, submitted a draft to the council proposing this codification of law of evidence. That report of Third Law Commission in fifth report contained 39 sections, but it was also found to be inadequate. Subsequently in the year 1868, Sir Henry Maine was appointed as a distinguished jurist, was appointed as the chairman and to codify this law. But his attempt also was failed. Then after that, finally, the process of the task of codifying Indian evidence was entrusted to Sir James Fitz-Stephen. He was between 1829 and 1894. He was a Sir James Fitz-Stephen is popularly known as the father of law of evidence. He was also authored Indian Contract Act 1872. So, the Sir James Fitz-Stephen was entrusted with the task of codifying this law of evidence, it was submitted to the council, and it was submitted to the council and legislative council, and it was referred to standing committee, select committee made some modification and submitted referring to the council, and this particular enactment titled the Indian Evidence Act was passed in the year 1872 and came into force on 1st September 1872. If you want, I will explain the full details of this historical background in topic wise, dear friend. This is for your purpose. So, this Indian Evidence Act, which was passed in the year 1872, came into force from 1st September 1872. At that time, this law of evidence was applicable to India, Pakistan, and other territories. So, and after our independence and after our Constitution of India, also this enactment, the provisions of this enactment are being continued till date. This enactment is more than 250 years. At the time of enactment, the Indian Evidence Act contained 167 sections divided into 167 sections divided into 11 chapters. These 11 chapters containing 167 sections, the Indian Evidence Act contained 167 sections divided into 11 chapters and broadly categorized under 3 parts for the purpose of scheme of the Act. So, in this lecture, I will let you know section wise, topic wise, and part wise to the best of my ability. I will complete all the topics in this lecture. Now, this enactment, the Indian Evidence Act, which was passed in the year 1872, witnessed so many amendment acts. There were 28 amendment acts as on 31st October 2019. And meanwhile, the Indian Evidence Amendment Act the 2021 was passed. The 2021 was passed. This act, proposes section 114AA to section 114A, section 114A already is there. Transfer of burden of proof shifted from prosecution to defense, that is there. And 114AA has not yet been implemented because the new act enactment Bharatiya Saksha Adhiniyam has come. That is why, similarly, there is the 2022 amendment bill is there to expand the definition of document under section 3 of the act. So, this is the position with reference to this act. Dear friend, the act, Indian Evidence Act, contained originally 167 sections divided into 11 chapters and categorized under 3 parts for the purpose of scheme of the act. To these 168 acts, there are additional acts added. 20A, 53A, 111A, 113A, 114A, like that. These type of additional sections are 18. So 167 plus 18 comes to 185 sections. Practically speaking, there are 185 sections divided into 11 chapters and categorized into 3 parts for the purpose of understanding of this particular subject. Now, this is the overall overview of this Indian Evidence Act. Now, dear friends, we have to discuss about we have to discuss about the scheme of the act. The scheme of the act, to discuss about the scheme of the act, the Indian Evidence Act as a whole has been categorized under 3 parts: part 1, part 2, and part 3. Part 1 contains part 1 contains 55 sections. Part 1 contains 55 sections. first section 1 to 4 chapter. This part 1 contains two chapters. First chapter, chapter 1, contains 4 sections 1, 2, 3, 4. These 4 sections deal with preliminary aspects, preliminary concepts. Section 1, title, extent, applicability. Section 2, repealing act. Section 3, the interpretation clause, that is definitions, certain definition. 4, presumptions. 4 presumptions. Then second chapter contains section 5 to 51, 51 sections. Second part 1 has 2 chapters. First chapter contains 4 sections. These 4 sections I will give special lecture. 4 sections. Section 1, title, extent, applicability. Section 2, repealing act. This repealing act is placed in under section 170, chapter 12 in the new enactment of the Bharatiya Sakshya Adhiniyam. So here in present World Act, part 1 contains two chapters, 4 sections. In new enactment, part 1 contains 2 sections only. So this part 1 is split into 2 parts in the second chapter. I don't like to confuse by making comparison now itself. In course of time, you will be able to understand each and everything. Let us now completely confine to old enactment on which you are going to face the examination. Here, part 1, first chapter, preliminary, 4 sections. Second part is 5 to 55. These 5 to 55 speak about relevancy of facts. Relevant facts are relevant facts. So what are the relevant facts? When an individual wishes to approach the court, that the court will decide only relevant facts only. Only relevant facts are entertained. Any irrelevant facts will not be entertained at all. What is fact? What is relevant fact? I will let you know shortly. Court will entertain only relevant facts. What are the relevant facts? We will discuss. So, other than relevant fact, the court will not decide. Now, section 5, chapter 2, section 5 tells one thing. 6 to 55 provide various provisions for, according to section 5 says that a fact to be decided by a fact to be admitted in court, it must be in existence. First reason. Second one is it must be relevant directly or otherwise. Third, irrelevant facts will not be entertained. Okay. Part 1, chapter 1 contains 4 sections. 4 sections we will discuss later. Part 2, chapter 2, 5 to 55 sections. That means 51 sections are here. Only one section tells the court will entertain only relevant facts. What are these relevant facts? A fact to be relevant, it must be in existence. The fact must be in existence. Secondly, it must be a relevant fact. Relevant fact in the sense, it must be legally relevant, it must not be logically relevant. Thirdly, irrelevant other than these above, the irrelevant are considered to be irrelevant facts, they cannot be accepted for evidence. That is the point. So, section 6 to 55 provide various occasions, various instances. Though the facts are directly not relevant, they are otherwise relevant. What are the various instances we have to discuss? So according to section 5, only directly relevant facts, facts in existence, directly relevant facts, they are not otherwise relevant, but directly relevant facts are admissible. So irrelevant facts not admissible. Though though they are not directly relevant, otherwise relevant, are provided under section 6 to 55. What are the various concepts in this from 5 to 6 to 55? I will explain it very clearly. Next one is part 2. Part 2 speaks about on proof. On proof or proof of facts. On proof or proof of facts. This means mode of proving. Mode of proving means to prove. Second is, okay, first thing is court will accept only relevant facts. Okay, parties come with relevant facts. Oh, in what way you are proving? What way you are proving? Okay, you are coming to our you have come forward to supply some material. How you will provide? You supply that by railway transport, air transport, or road transport. That will be the question. So how you will provide? So the court will entertain certain modes of proving only. It is by that means if it is relevant fact, though not directly relevant, otherwise relevant, the court is ready to entertain your issue, provided how you what is the methodology you are going to adopt to prove the particular fact in evidence. That is the thing. So by oral evidence, oral evidence or documentary evidence, secondary evidence, hearsay evidence, circumstantial evidence, like that. That is the different means of evidence are studied under part 2. Part 2. Part 2. Part 2, section 56 to Section 56 to 100 lay down various provisions relating to this proof of facts or mode of proving the facts. Then the third part contains the third part contains 101 to 167. 101 to 167. So in this particular play, production and effect of evidence. The part 3, production and effect of evidence. In this particular production and who shall prove? Who shall prove? Who can testify? Who can be called for evidence? Who must not be called for evidence? So production and effect of evidence. So the relevant facts directly or otherwise, okay, the facts that are coming to court either directly relevant or otherwise relevant. First point, okay, mode of proving, they are ready to produce by oral evidence or documentary evidence, secondary evidence, circumstantial, okay. Who are the persons? Every man going on the road cannot be called for interview. Who can testify? Who is the person qualified to give evidence? What are the persons? They must be connected persons only. So who must not be called for interview? Who can be called for? Who must not be called to court for giving interview? Who can be called for interview? Who can be called for evidence with prior permission of the authorities? And like that, who can be compelled to give evidence? Who cannot be compelled to give evidence? These aspects are enshrined under Part 3, Section 1 to Section 101 to 167. So here, Part 1 contains two chapters containing Section 1 to 55. Part 2 contains 4 chapter 3, 4, 5, 6. 4 chapter containing Section 56 to 100, 45 sections. Part 3 contains 67 sections. Section 101 to 167 containing 2, 4, 5 chapter. 7, 8, 9, 10, 11. 5 chapters. 5 chapters. Part 1 2 chapter, part 2 4 chapter, part 3 5 chapters. These are the topics we have to discuss. Now let us now go to first part, dear friends. First part, dear friends. So here part 1 contains 2 chapters. Chapter 1 contains 4 sections. Section 1 tells you title, extent, applicability. The Indian Evidence Act is called Indian Evidence Act. It applies to whole of India, including the state of Jammu and Kashmir. After Jammu and Kashmir Reorganization Act in 2019, earlier in all enactment except the state of Jammu and Kashmir, the special status to the state of Jammu and Kashmir was withdrawn, and the Jammu and Kashmir has been made union territory, is what you are expected to know, dear friend. Section 2, Repealing Act. Repealing Act means when an act is passed, some previous laws inconsistent with this are to be or stand extinguished. This type of when Indian Constitution was made, Article 13, Clause 1, all the laws which were prior to Indian Constitution, inconsistent Indian Constitution are unconstitutional. All laws, so the laws before Indian Constitution must be according to law, Indian Constitution. After passing legislation also according to how it was 13.1 and 13.2 was fixed. Here also any whatever legislation which do not provide any authority, the principles of evidence we supported by any proper authority or legislation are stand abolished according to section 2 of section 2. Section 3, interpretation clause. Any enactment, any law, any enactment, any codified branch of law, the section 2 contains definitions. That is interpretation clause. In some enactment, it is section 3. But this Evidence Act, old act, section 3 contains interpretation clause. A new enactment contains section 2 is interpretation clause. So this section 2 is shifted to 170. Coming to the point. Now, 3 interpretation clause. In the interpretation of what is court is defined, evidence is defined, document is defined, and more particularly fact, prove, disprove, not proved are defined. Fact, relevant fact, fact in issue. So, dear friend, it is very, unless you know about fact, relevant fact, fact in issue, you won't be able to understand the subject. That is why let me explain in brief about fact, relevant fact, and fact in issue. So what do you mean by fact? Fact means absolute truth. I am a man is a fact. It is a table, it is a chair. So what all the things, whether it is in solid condition, liquid condition, or gaseous gas condition, that is anything state of things capable of perception is a fact capable of existence. We have 5 senses. What are the 5 senses? Eyes, ear, nose, tongue, and skin. With the help of our 5 senses, we will be able to know what is what. We need not have any internal knowledge or special knowledge. That is it. So the second, this definition of fact has 2 columns. First line speaks about external fact. Second line speaks about internal fact, psychological fact. So psychological fact. So the fact is absolute truth. It is in physically, it can be, it is either it is in physical condition or in mental condition. If it is in physical condition, it is called physical fact or external fact. If it is in a mental condition, it is called internal fact or psychological fact. For example, 2 boys are going on the road. Who are going on the road? If anybody asks, 2 boys are going. Suppose they are 2 if you know that both of them are law students, 2 law students are going, you can tell. That is a psychological fact. So fact. This This is fact to relevant fact. Fact is over. It may be external or physical. So second one is relevant fact. Second one is relevant fact. What is details? I will explain in detail in next chapter. To tentatively, I tell you relevant fact. What is relevant? One fact becomes relevant to other if there is any causal connection. That is relevant fact. Suppose you are a qualified means your degrees are relevant. If you are rich man means your properties are relevant. If you are a good man means your service to public is relevant. You are a bad man means you are giving trouble to a public. That is, they are relevant. So there must be causal connection between one. Suppose a person is found guilty, he arrested on an allegation of theft. So whether he committed theft or not is to be proved. So if anybody says that no sir, he is a very rich man, he has a lot of property, there is no need for him to steal, that is not relevant. So whether he has stolen or not, if the plot is relevant, that relevant fact has to be ascertained. That issue is to be ascertained. So relevant fact. This relevant fact is two types. One is legal relevant, other is logical relevant. One is legal relevant, legally relevant, other is logically relevant. Legally relevant is enforceable, logical relevant is not enforceable. Enforceable in the sense one can get it done through court of law. One can approach court and get relief. That is enforceable. Suppose wife and children can file a case against father, parent, family head, parent for maintenance. That is legally relevant. If wife sues husband for diamond necklace and child, daughter or son files a case against father for a sports bike, it is not relevant. So legally relevant and logically relevant. Legally relevant and logically relevant. So now what is the third one? Fact in issue. Fact in issue when there is a conflict of opinion between two parties as to some right or liability. When there are two opposite views relating to a particular material fact, one person say yes and other person say no, so either it may be yes or it may be no. Either yes may be right or no may be right, but according to he is right, according to B is right. So when there is a opposite, when the two parties approach the court of law, they express two opposite views and to fructify their view, to they put forward their arguments and supporting witnesses. The court, on hearing both the sides, will come to a conclusion and which side is having more weight and will give the judgment. Suppose, for instance, a debtor takes 1 lakh rupee loan from creditor. Despite several reminders, debtor doesn't repay. Then creditor files a case against debtor. In court of law, debtor tells, I have not received. Creditor tells, I lent him 1 lakh. So the two parties, who is right, both will bring the supporting evidence, and then when both the parties bring the supporting evidences, then after in judicial inquiry, the ultimately who is right, who is wrong will be ascertained. Whether A has credit, whether A has lent 1 lakh to B or B has borrowed 1 lakh from A, that question is called fact in issue. Fact in issue. A killed B. B died is a fact. Somebody killed is A killed is a fact. But there is an issue. While awarding, if before giving a punishment, the court will take into consideration general defenses and other things. Whether A intentionally killed, if it amounts to culpable homicide or murder, the court will award life imprisonment or death sentence. Whether A by negligent driving killed B, it attracts section 304A and A will be awarded 3 years imprisonment, fine, etc. Suppose A is accident, he driving the vehicle, suddenly he got heart stroke, or some child or somebody, suddenly one motorcyclist entered into the road, he turned the steering, and it is like an inevitable accident. He is protected under section 80 general defenses of Indian penal code. He may be exempted from the criminal liability. Suppose the A is insane, mental disorder. He is a patient undergoing treatment in mental hospital, but he is a imbalance of mind. He will be exempted from criminal liability under section 84 of the Indian Penal Code. That is fact in issue. That is fact, relevant fact. Fact in issue is over. Then fourth one is section 4 is presumptions. Presumptions mean in the absence of absolute truth, the court will go for presumptions. Suppose whenever a crime is committed, the criminal will not go to police station and give confessional statement, I committed a crime like this. After the scene of offense, he will run away. Whatever crime he committed, the culprit will run away. The accused will run away. So when there is no evidence that so and so committed, somebody died, who killed, there is no any evidence. But the law is there to punish the culprits. The culprit should not be left alone. If they are left alone, they will commit crimes again and again. For that purpose, what happens is the court will go for presumption. Presumption in the sense, suppose if Mr. X is there, he is expected to be in this time at home. If he is not at home, he is in office. If he is not in office, he is in friend's house. He is not in friend's house, he is expected to be in club. That is the presumption. So presumption. That is the presumption. So his availability in club or office is presumption. There is a likely possibility. It is not absolutely immune from this particular thing. It is not directly relevant, it is otherwise relevant. Those facts are to be taken into consideration from. So here presumption means some assumption, some guessing. In order to punish the person, we have to guess. There is no any, in the absence of any witness, the court will think about this guessing. This presumption is of two kinds. Basically, presumption of fact or natural presumption or may presume. In may presume, if a person A is found, A is arrested for possessing gold, like Kasturilal case in Kasturilal case in Loft Arts. But whether it is a stolen property, or he purchased from a thief, or he is a real owner, the court may consider depending upon the facts and circumstances, evidence produced on the particular case, the court either may come to a conclusion it is stolen property, or it is the stolen property purchased according to section 411 IPC, or it is he is the real owner. Like this opportunities are there. That is may presume, or natural presumption, or presumption of fact. Second one is presumption of law or artificial presumption. Presumption of law or artificial presumption. This presumption of law or artificial presumption is two kinds. One is rebuttable, second is irrebuttable. Rebuttable means challengeable, irrebuttable means not challengeable. For example, a person is selected for a job, for a lecturer job or clerk post, and he is given appointment basing on his degree certificate. In this. Suppose still that the other candidate who could not get the job may challenge it. The degree certificate is not genuine. That certificate is not recognized by the university, so and so university. UGC recognize some universities. University Grants Commission do not recognize certain universities. It may be challenged. Otherwise, the particular university may take decision in management council. So some mass copying took place at a particular center. All the degrees awarded are cancelled. Even though when once a documentary evidence is produced, it is a primary evidence, is most important evidence, the best means of evidence, but still the court can be challenged. It can be challenged. So irrebuttable, that is shall presume. First one is may presume. Second one is rebuttable. Presumption of law or artificial presumption or shall presume is called it is rebuttable. Next, presumption of law or artificial presumption. Second category is irrebuttable presumption, that is conclusive proof. So here may presume or artificial may presume or natural presumption or presumption of fact or natural presumption or may presume, that is first one. Second one, presumption of law or artificial presumption. These two kinds. One is rebuttable presumption, that is shall presume. Irrebuttable presumption, not challengeable, it is conclusive proof. Suppose after decree of divorce, wife and husband, decree of divorce is sanctioned, granted to one couple. They are no more couple. Suppose if they want to challenge, they can go for a higher court and appeal to challenging this divorce given, but it cannot be challenged in another court, because whatever the court judgment given by decree of divorce given by court is conclusive. It cannot be, there is no further evidence on that particular issue will be accepted to revive the decision of the court of same competent jurisdiction. If at all the agreed party wants to go, he or she may approach the higher court for further relief. So this is the position. So section 1, 2, 3, 4 is over, and now we have to before going to part 2, we shall speak about the meaning of evidence in brief. The word evidence is derived from the Latin word evidentia or evidere, which means being clear, to discover, to find out truth as per Dharma Shastras. That is, until and unless evidence is there, the case is very complicated, very confusing. For example, take the case of husband and wife who are disputing. If when you hear the voice of wife, you think that wife is good, husband is bad. When you hear the voice of husband, you think that husband is good, wife is bad. When both the parties are brought before the court, and with the supporting evidence of both the sides, the court will be able to understand who is right and who is wrong. Depending on the more weight, the court will pass a decree for divorce or restitution of conjugal rights, whatever matrimonial remedy being sought in that particular case. So evidence is only evidence that makes the dispute clear. It is only the evidence that makes any problem clear. That is why, in the absence of source of law, like legislation, custom, precedent, or whatsoever may be, the judge will be able to deliver judgment without any supporting source of law, but no judge will be able to deliver justice without evidence. But with reference to applicability of the court, the evidence in first section 1 I forgot, the law of evidence is applicable to all courts, including the state of Jammu and Kashmir. It is not applicable to certain quasi-judicial bodies, that is affidavits before officer or court or some judicial inquiry. It is not applicable to arbitrators. It is not applicable to applies to court martial other than the court martials governed by Army, Navy, Air Force. These three, they have special enactments, and those laws are governed. So even though some tribunal, railway tribunal or income tax tribunal, certain tribunals, the law of evidence is not applicable. So the law of evidence, principles of law of evidence, Indian Evidence Act 1872 are not applicable to certain areas. Doesn't mean that for those trial of those particular judicial bodies, law of evidence is not there. For every judicial inquiry, for every judicial proceeding, quasi-judicial proceeding or quasi-judicial proceeding, judicial body or non-judicial body, they have their own principles of law of evidence. Without any principles of law of evidence, no case can be decided. So they have their separate thing. So what is this in introduction? First chapter I will give you in deep about this. So the evidence. So here the word that means after evidence only the matter will be clear. The word the term the word evidence is a Latin word evidentia or evidere, which is means being clear, to ascertain, to find out, to discover what not everything, and as per Dharma Shastras to find out truth in fact in issue. It is only truth which is the nucleus of the entire law of evidence, the entire the tree of law of evidence, that provides oxygen to the many provide oxygen to many branches of law. That is corpus juris is what I said in the beginning, dear friend. Now let us go to next thing. Evidence. The evidence, there are three fundamental principles of evidence. Number one, the evidence, when the party come to give evidence, he should speak the fact in issue as far as possible. Don't speak cock and bull stories. The court will not give much time to speak so many things. What is the problem there? What is the fact in issue is there? Relating to that fact in issue only you have to speak a little. That is what the court insists. That is the best, the matter, the evidence must be confined to the fact in issue is the first fundamental principle. Second fundamental principle means, as far as possible, the best means of evidence must be given. Among all means of evidence, oral, documentary, primary, secondary, circumstantial, all the evidences are different kinds of evidences are there. But among all, the best means of evidence is documentary evidence. And documentary evidence is the best mean. In the absence of documentary evidence, then secondary evidence may be taken into. Suppose the degree, qualified MA degree, if it is not there, the Xerox copy or attested copy, that is secondary evidence. And then original evidence means oral evidence. Oral evidence means the human being himself, the witness himself will come to witness box and give evidence like this. So among all evidences, the best means of evidence is documentary evidence. If documentary evidence is not there, secondary, oral, like this, you have to discuss. That is second point. Third point is hearsay evidence is no evidence. Hearsay evidence is no evidence. So when you say that A stole B's scooter, C tells that, sir, B has stolen A's scooter. Have you seen? No, sir, my friend D told me. That is not. So don't never say your friend saw, your brother saw, your sister saw. But whether you have seen or not, if you have seen while B is stealing A scooter, then you tell. Hearsay evidence is no evidence. But however, to protect the protect the interest of the parties concerned and to uplift the ideals, goals of justice, certain times hearsay evidence is acknowledged, entertained, and section 6, section 32 dying declaration are the best examples which we are going to take up shortly. And next one is next thing is for the third one is first fact in issue. Evidence should be confined to fact in issue. Second, the best means of evidence must be given. Third one is hearsay evidence is no. There are the fundamental. There are two more points. That is quid probandum, modus probandum are the fundamental principles of law of evidence. Quid probandum means thing to be proved. Modus probandi means of proving. When what is to be proved, how it is to be proved, in what way it is to be proved. Suppose the students want to go for a pleasure trip, whether they want to go to Bombay, Delhi, Calcutta, they have to fix which place they want to go. They fix how they want to go. They go by flight, they go by train, or they go book some vehicle and go. That is there. So where they go, how they go, like that. What to be proved, how it is to be proved. Quid probandum and modus probandum. Thing to be proved, mode of proving. These are the main fundamental issues of law of evidence. Now let us go to chapter 2. Chapter 2 under part 2, section 5 to 55. Section 5 of the Evidence Act tells that if court will entertain only facts which are in existence. Which are in existence. Suppose you go to showroom of car showroom. If the car is readily available, that is in existence. If car stock is not there, it is for showroom purpose. If you book the car, it will come 1 or 2 months later. But still it can be either it should be in existence, that's first, or either it must be relevant. It must be relevant. Going to car showroom and if you ask cycle, it is not relevant. You go to car showroom and ask lorry, it is not relevant. It should be relevant. So the relevancy also must be legally relevant. What is legally relevant? I told you. Legally relevant. Nothing other than that. So section 5 enunciate that the facts are said to be, the court will entertain only relevant facts. A fact to be relevant fact, it must, there are three laws. Number one, the fact must be in existence. Secondly, it must be relevant. That relevancy must be legally relevant, must not be logically relevant. Third one, other the only about anything other than this is declared to be irrelevant. It cannot be entertained by the court for evidence. This is section 5. But section 6 to 55 give you various instances, though there are so many facts. They are not directly relevant, but they have connection, indirect connection or causal connection to make that particular fact as a relevant, and it can be admitted in evidence. So that is what are these various things we have to do under part 2. Now coming to the section 6. Section 5 part 2 is over. Section 6. What is section 6? Res geste. Res geste. Res geste, independent question may be asked. In Indian Evidence Act section 6 speaks about res geste. In new enactment section 4. Section 4. What res geste means? Mystery. Fact story behind. Fact story behind. So facts forming part of the same transaction, though not directly relevant, but otherwise relevant. Otherwise relevant. For example, A and B is there. A warns B in the presence of bystander D, E, F. I can no more tolerate you. I will see that your body will float in our village tank within 1 week. He gives warning. Means A threatened B that A would kill B within 1 week in the presence of others, C, D, E, F. As he said, after 1 week, the body of B was found floating on the village tank. So how he killed? Who killed him? Nobody knows. But no one of us have seen how he died, who killed him, and threw him in the village tank. We don't know, sir. But when police, VPS. From 1 week back, last week, Mr. So-and-so gave warning to B, the deceased, to kill him and threw in this village tank that was there. And some other say, when I was returning from town last week, I went to neighboring town and returning from my bullock cart. In front of some so and so, one bullock cart was lying, and that bullock cart, one dead body was there. And assuming that he was a living body, I wanted him to give side, but having heard nothing, I physically went to that bullock cart, observed found the body, one dead body found on that bullock cart, that in front of so and so. There are some statements may be given. These statements, though not directly relevant, they are otherwise form part of the same transaction, and hence they can be admitted into evidence. Section 6. This section 6 was studied under section 4 in new act. And the next one is section 7. Section 7 means occasion, cause and effect. Occasion, cause and effect. So suppose A wants to rob gold jewelry from a woman. A is a thief, B is a woman with wearing jewelry. So he is looking. He cannot rob in the presence of other. Occasion. When she was alone at home. She was alone at home. That was the occasion. Occasion. Cause. Cause means he wants to kill her or rape her or beat her whatsoever. The cause is to rob the jewelry. Then effect. Effect means after killing this, the effect means severe loss or injury or death to woman and financial gain to this man. So that is occasion, cause, effect is there. In New Act, Indian Evidence Act, Section 7 speaks about it. In New Act, it is Section 5. Section 8, very popular, motive, preparation and conduct. Section 8 speaks about motive, preparation and conduct. So, previous or subsequent. Motive means, in this particular case, physical act and mental act, both are motive. Motive generally, good act is compared with motive means good object, malice means bad object. But in this particular section, motive refers to good and bad, good act and bad act. Motive, preparation and conduct, previous or subsequent. What is the motive? The motive is where A wants to win in the election, B is there. So long as B is alive, A cannot win the election. The thing is, if A wants to win the election, B should be dead. In order to in order to become MLA or MP in that particular area, A's motive is to become MLA or MP in that particular area. That is motive. Preparation. He purchased revolver or poison or something to kill B, or he engaged some Gondaras, some criminal, paying some sufari, some 5 lakhs, 10 lakhs like that. That is the preparation. Conduct. Conduct means the person will go, he will go and kill him and run away. After a commission of an offense, he absconds. That is the subsequent conduct. Subsequent conduct. So before conduct, subsequent previous conduct means going with intention to kill, commit the crime, killing. That is previous conduct. Subsequent after killing, running away. That is subsequent conduct. This is number section 8 speaks about the details I will explain. Section 9 is identification of things or persons or identification period or test identification. Section 9. In a new act it is section 7. Section 9, test identification or identification period. Suppose a woman is going on the road, some snakes, somebody by a motorcycle snatched her chain and she received some injury on the neck and she went to police station and the police told, okay, I will inquire into the matter, investigate and will bring some professional culprits and place bring you come to police station tomorrow or evening, he will tell. Accordingly the woman goes there. In that particular case, some professional chain snatchers, so 5 to 6 persons will be there. Among them, who is can you identify who is the anybody is there among out of these 6? Can you identify anybody who snatched your chain? She will have to identify this man or that man, or otherwise there will be so many chains. What is your chain? You have to identify. She has to identify that. This topic I will explain in detail in this. This is what is called identification period or test identification. And next one is section 10, conspiracy. Conspiracy means when some crimes take place by 2 or more persons. Some 2 or more persons commit crime. When 2 or more persons enter into an agreement to commit an illegal act or legal act by illegal means, They are called conspirators, joint criminals. Joint criminals. If one person is absconded and other person is caught, the evidence given by one conspirator will be admitted in order to convict the second conspirator also. That is conspiracy. Conspiracy. Conspiracy, Section 120A Indian Penal Code defines conspiracy. Section 120B prescribes punishment for criminal conspiracy under Indian Penal Code. So conspirators are person, those two or more person, they enter into agreement to commit an illegal act or legal act by illegal means. Each individual is called a conspirator. And this is next one is section 11. Section 11 speaks about most important topic, most important topic, alibi or alibi. When facts not otherwise relevant become relevant. When facts not otherwise relevant become relevant. Alibi. Alibi, this is most popularly made use of to get exemption from criminal liability. In most of the so many movies we've found this. Suppose A committed crime, A killed B. At the time of criminal proceedings, the defense lawyer from A tells that my client A is not available in that particular spot of commission of the crime. At that time he was in Delhi or he was in foreign country, like that he may tell. So, but because one person cannot appear on two places. So that is this alibi is a good defense to culprit to get exemption from the criminal liability. So because one man cannot appear at two places. So this for example, one particular crime is committed at a particular place in a particular city, but when the accused is presented before the court, the defense lawyer tells that my client is not available on that particular day. He was in another city participating in some seminar, like that. He will bring witnesses, document. He will bring some witnesses and produce documentary evidence, documentary evidence if necessary, and get exempted from, escape from the criminal liability. That is alibi. Alibi. Then section 12, suit for damages. So when the parties for breach of a contract, breach of tort, when they file a case against one another, the aggrieved party, when plaintiff files a case against defendant, whatever facts and information they present in a pleading, they are believed to be relevant according to section 12. In New Act it is section 10. Section 13, custom. So the custom, achara paramo dharmaha, the customary practice with that confers certain rights and customary practices must be respected. So there are several religions are there, several races are there. They have some customary practices. The rights emerged under certain customary practices are to be acknowledged. They can be treated as though not relevant according to law, if they since they emerge from customary practice and traditional rights, they are to be acknowledged. That is section 13. Section 14. Section 14, present Indian Evidence Act, section 14. New Act, two numbers less in New Act for all these topics. And section 14, state of mind, bodily feeling. State of mind and bodily feeling. State of mind and bodily feeling. State of mind, bodily feeling. What is here? They are relevant. For example, in office, one employee behaving another woman employee. The state of mind, one employee wants to trap B, whether married or unmarried. So he has an idea to trap a woman. That is mentally state of mind. So a male employee wants to trap a woman, B employee. The idea Yes, whatever is there in A's mind is called state of mind. Bodily feeling. The A goes to have beach seat very frequently, necessarily and unnecessarily, like that, speaking this or that, looking in a different way, like this. They are called bodily feeling. Similarly, a woman may behave like that with his boss or manager to trap him, moving with him clearly in dress code and everything. So she wants to trap that boss or colleague to marry him, as if we see in some movies, going to him frequently and trying to touch his body like this. So this is in this particular case, state of mind is mens rea, bodily feeling is physical act or actus reus. Physical act or actus reus. And then one is the next fifth one is, next one is section 15 facts. Facts bearing whether an act is accidental or intentional. Section 15 speaks about whether a particular act is accidental or incidental. To find out that in this particular case, section 14, mens rea and physical act both are here. In this, whether a particular act is accidental or incidental, only mens rea is there. There are so many accidents. Some of the accidents may be incidental, but it is very difficult to find out whether it is incidental or intentional or not. So in this particular case, if mens rea alone is there, physical act is not there. That is why it would be difficult to prove beyond reasonable doubts whether it is accidental or incidental. If any information relating to prove whether it is incidental or accidental shall be taken into consideration, that is section 15. Next one is section 16, existence of course of business. Existence in course of business. Existence in course of business means everybody is presumed to be sane until and unless contrary is proved. Similarly, when a business is going on, transaction is going on, everything is done as per rules only. When we go to register our house or purchase any property, when we purchase any article, some documents are there, we sign it, we come back with the document. We don't read out the contents of that because they are presumed to be in right condition. We trust it, we believe it. The issues relating to that are accepted as relevant. So section 16 is over. Now section 17 to 31 of Indian Evidence Act, all these sections speak about admissions. All sections speak about admission. Section 17 to 31 of Indian Evidence Act speak about admission. Admissions means section 17 to 23 and 31, section 17 to 23 plus 31 deal with admission, 24 to 30 deal with confession. What is admission? What is confession? Here, once statement, if I speak about myself, they are called self-regarding statements. If I speak good about me, that is self-serving statement. If I speak bad about me, it is self-harming statement. If anybody tells good about him, nobody will believe. If anybody tells bad about him, the court will believe. So, self-serving statements are not admissible, but self-harming statements are admissible. Those self-harming statements which are admissible in court to prove in evidence, they are called admissions. These admissions in civil court, civil litigation are called admissions. Admissions in criminal court are called confessions. If the debtor agrees before judge that I have received money, that is admission. That is admission. If culprit, if accused agrees before, makes statement in court that I have committed that murder or crime, it is confession. It is confession. So in admission, who are the persons called qualified to give admission? That is, we have to read. So the parties to the court, the person interested in the authorized person, these aspects I will explain in detail. In confessions, section 24, confessional statement made to police officer by fraud, inducement, not allowed. Suppose a magistrate tells, you give me, you agree that you had this crime you have committed, I will reduce your punishment. That is by inducement, fraud, something. It is not allowed. Confessional statement made to police officer, outside or in police. Outside, section 25. Inside, police custody, not allowed, not police. Section 27. A arrested person in police station tells, I committed that murder, not allowed. If you, I will show you where I buried that body in my garden, some so and so tree, behind one a particular tree. I buried that dead body. If you take me, I will show you the body, he tells on his own. Then the police, the second part of the statement gives clue for quicker investigation, and as per the clue, the matter is detected, the material fact is detected. Then section 27 is active. Is relevant, though it is made to police officer. That is section 25. If the confessional statement made to police officer in the presence of magistrate in police custody, it is admissible according to section 26. So these are the issues we will have to speak in admissions and confessions chapter. After admissions and confessions, then we go to dying declaration. Most important, persons who cannot be called for evidence. Suppose A killed B and ran away, and A is that ray of life, and he is about to die. Somebody asked, what happened? So and so killed and died. So the statement made by a person who is about to die. A person who is about to die would not lie. If the person who killed absconded, ran away. Similarly, A committed accident and hit and run case. He dashed a pedestrian and ran away, and that body is the body was fighting with life, and some bystanders come. By the time bystander asked what happened, he said something by spoken words or writing with blood-stained hands or something, gesture, and died. That will be treated as dying. Pakal Narayan Swami case is the relevant case on this point. I will explain all these things in detail. Res gestae is most important topic. Admissions and confessions are important topic. But all confessions are included, can be called as admission, but all admissions cannot be called as confession. So confession is an admission is an admission, but admissions in civil cases are called admission. Admissions in confession cases in criminal cases are called confession. That is why the quotation is all confessions are admission, but all admissions are not confessions. This is the position. Admission is wider, confession is narrower. So this is over. And dying declaration. Dying declaration, in the absence of any truth, the dying declaration has to be taken into consideration. These admissions and confessions are studied in section 17 to 31 in present Indian Evidence Act. They are studied under section 24 to 30 in new enactment. Next, dying declaration. Next topic for discussion is next important topic for dictionary. There are when an enactment is there, each and every section we need not study. So burning sections, one single section may speak about big topic. Section 6 speaks about big topic, and section 32 speaks about big topic, like that. So that areas you have to concentrate. Next, judgments when relevant. Some judgments when relevant. Section 40 to 44. Judgments when relevant. It is 34, 38 in new act. Judgments when relevant means there are some publications are there. So Mr. So and so won the election. So and so won the World Cup. Like that. So important facts which are known to all public need not be proved. Second, for next section, it is the duty of the court to find out the truth of a particular relevancy. Like that. These are the issues. What facts are judgment? When previous judgments are relevant, that is to be taken into consideration. When judgments, we studied about the judicial precedent, when the judgments are to be, what judgments are to be relevant in particular case will be decided. These topics we will discuss in detail. Next, opinions of third party, third persons are experts' opinion. In course of judicial proceedings, it may be civil proceedings or criminal proceeding, the opinions of some persons, so signature, thumb impression, sir, foreign language, so many things are there. That particular document or oral or something, document evidence, the court will not be able to understand, the parties around will not be able to understand. Then there is a need arises to call for particular expert. That is what opinions of expert. That is a post-mortem report expert may come, fingerprints man may come, whether document is real or forged, the signature expert will come. That is the opinions of expert will be studied under section 45 to 51 in Indian Evidence Act. The same provisions are there under section 39 to 45 in new act. Character when relevant. So generally speaking, character is not relevant because there is a habitual, there is a thief. Regularly his business is theft. He commits theft every day or something. Suppose when a particular theft is there, whether he has committed or not is the question. He committed theft several times, is not relevant. His character is not relevant. So character is not. If there is a criminal, is a Gondaraj, he committed crimes so many times. Whether a particular murder, he previously committed so many murder, this murder also he might have committed, is what we cannot say. But his previous conduct character cannot be relevant to make him guilt. So whether this particular crime he committed or not, the court will say. However, the character will be taken into consideration in certain cases. In a joint family, widow is there. Her husband died. Being member of the joint family, she wants to, according to New Section Act 2005 Amendment Act, she is like a co-partner. What is there? She is inheriting the property of the deceased husband. As a member of the joint family, she is enjoying the property. She enjoys the property of the husband, provided she must be eternal. She must not have adulterous activity with anybody. She must not remarry. So she must be virgin. So even after having lost her husband, she should not go for remarriage. She should not have any extramarital affair with anybody. In that particular case, to inherit the property, her character would be taken into consideration. Otherwise, not. That is this thing. A character normally will not be taken into consideration. In certain cases, the character will be taken into account. So that is about character when evidence. Now we go to first part is over. First part 52, 50, 55 deal with character when relevant. The part 1 is over. Part 2, these part 2 and part 3 are very small topics. Don't worry, I will explain all these things in detail. In part 2, section 3 to 6, 3, 4, 5, 6, 4 chapters are there. 4 chapters on proof or mode of proving. What types of evidence? Documentary evidence or document 56 to 100 deal with proof of facts which need not be proved. How to prove? Where you prefer relevant facts is over. How you prove? By documentary evidence you want to prove, circumstantial evidence you want to prove. What are the mode of proving? Proof means mode of proving. What means you want to prove is what we study in part 2. Part 2 has 4 sections. Section 4 chapter. Chapter 3, Chapter 4, Chapter 5 and Chapter 6. So here Chapter 3 speaks about facts need not be proved. Facts which that is previous court judgments. In certain facts need not be proved. So Court is asking, okay, it is relevant, first is over, you have to prove. How you will prove? Oral evidence or documentary evidence, this thing. So, for the very beginning, the beginning section, section 56 to 58 in New Act 51 to 53. 56 to 58 say that facts which need not be proved. Facts which need not be proved. There are universally established facts need not be proved. Everybody knows. The particular individual need not prove it. Need not prove it. So and so is the chief minister of so and so is the prime minister of so and so happened. These are universally known, such things no. In the another section, 56, 57, the court has to take effort to make judicial notice, and 58 speaks about some other issue. So, the facts, the parties to the suit need not prove it is they are universally published, and the court will have to take efforts to find out. That is one. Second, section 59 or 60, oral evidence. Oral evidence means if a man gives evidence, that is called oral evidence. What is oral evidence? Various issues. I will take up special chapter. Section 59 to 60 speak about oral evidence. Oral evidence independent chapter I will take up class. And 61 to 90A. These are all sections in New Act 56 to 93. For every topic there is a section numbers will change, there will be slight changes. So that is why whatever we study in Evidence Act will be useful to this also. Documentary evidence means there are various issues in view of this electronic media, computer storage, CC cameras, cell phones, WhatsApp messages, telex, telegram, so many things are there. Because of this, the concept of document has been enhanced, and to that effect, the Criminal Law Amendment Bill 2022 made proposal to expand the definition of this thing. In the meanwhile, new enactment has come, so that is there is no need of all that. That is why documentary evidence means evidence produced through production of documents. So this documentary evidence very lecture I will explain this in detail. Next, section 91 to 100, exclusion of oral evidence by documentary evidence. So in ancient Mohammedan criminal law, oral evidence is given more important than documentary evidence in those days. But today, documentary evidence is given more important than oral evidence, because documentary evidence is primary evidence. It is also superior evidence. It is documentary evidence is superior to oral evidence. That is why in the presence, in case the witness is able to produce both oral evidence and documentary evidence, the documentary evidence will be taken into consideration and the oral evidence will be set aside. That is the reason. What are the circumstances under which the documentary evidence can be set aside by the oral evidence? Rest. So part 2 is over. Next 6 chapters over. Part 3 about part 3 speaks about production and effect of evidence. In this case, who have to give evidence, how they have to give evidence, what are the various kinds of evidence, who can testify, how to examine the witnesses, who have to prove. All these things we have to study under this part 3. Production and effect of evidence. Part 3. It contains 5 sections. Section 7, 8, 9, 10, 11. Section 5, Section 7, 8, 9, 11, 12. These 5 sections. Part 1, 2 chapters. Part 2 chapters. Part 3, 4 chapters. Part 3, 6 chapters. These 6 chapters contain 167 sections. Section 101 to 167. These sections, part 3 we study. In this case, what we study? Chapter 7, section 101 to 114A. 114A, we study about burden of proof. The person who approaches court first will have the burden to prove. In the creditor files a case against debtor Defendant, I gave him 1 lakh, he has not yet repaid. Because you say that you gave him 1 lakh, you have to prove. The person who approaches the court must prove. Suppose the petitioner approaches petitioner wife, approaches husband for divorce or restitution of conjugal right, the petitioner has to prove. The petitioner has to prove. So the burden of proof, so many things are there. Legitimacy of child, consent of woman. In so many rape cases, the prosecution is proving that the defense is proving that the woman is having consent, and so many cases were dismissed. So in a criminal case, the prosecution has the burden to prove, but after Criminal Amendment Act 2013, the burden of proof is shifted from prosecution to defense. So section 114A, 1113A, all these aspects in burden of proof was good topic. The question may be asked on burden of proof. And burden of proof, all these sections I will tell you. And according to the burden of proof, section 101 to 114A. And new act 104 to 120. New act 104. Next burden of proof is over. Next, the 8th chapter speaks about estoppel. Estoppel, agent by estoppel, principal estoppel by estoppel. I spoke in previously in so many previous subjects. Estoppel means shut the mouth. Shut the mouth. Suppose when a person honestly believe a particular fact at the silence of a person, the person who trusted and confidently should not be suffered. Suppose A say that A says that I am the partner of that particular firm. If the partners keep quiet, believing that A is the partner of so and so firm, some party, some customer deposited some money with an intention to deposit some money to the partnership firm, that amount is given to A, assuming that he is the partner. So subsequently it is found that A is not the partner. When a partner's liability is joint and several, that aggrieved party demands return of money from partnership firm, they should not say, when so and so announced that he is your partner, you kept quiet, then you shut your mouth, then you shut your mouth, now you shut your mouth and give the money back. Like that. Partner by estoppel, agent by estoppel, I told you. These topics I will explain in detail. There are some cases, and medical seat was given, and she joined, and subsequently by mistake you are given a better rank, but there are some candidates with better rank, you have to vacate the seat. The university, the selection authority gave notice. Then the aggrieved girl approached the court. The court gave direction to the entrance examination authorities under the principle of estoppel. You got her selected as per your list. She took admission. She incurred lot of expenditure. You cannot say her withdraw. So when a candidate is received a letter from a competent authority stating that she has been selected for an admission of medical, then she joined, then subsequently they cannot say that. Similarly, results and other so many cases are there. The estoppel is very small topic, you can easily understand. So that is estoppel. Section 15 to section 115 to 117 new act. Section 121 to 123, section 115 to 117 old act, Indian Evidence Act. Section 121 to 123 new act. Next one is ninth chapter. Ninth chapter is witnesses. Who is a witness? Who can testify? So to prove in evidence must be given by some individual. Some who can testify, who can give evidence is first. What are the various categories of witnesses? So number one is there is no any age limit. Child can give evidence. Deaf and dumb can give evidence in their language. And person who is unable to speak can give evidence by gestures like this thing. However, who can be an ordinary people can be called for, can be summoned to come to court and give evidence. But state sovereigns, President of India, Governor, and ambassador, such people must not be called for before court to give evidence. Secondly, certain officials, magistrate, judges cannot be called for interview, cannot be called for evidence, give evidence, but with the permission of the higher authorities, they can be called for to give evidence. Then another thing is certain people cannot be, who can be compelled to give evidence, who cannot be compelled to evidence. These aspects we have to do. Sometimes while giving evidence, friendly witness, hostile witness, impeaching credit of evidence. Friendly witness means the evidence brought by party to give evidence in his favor is friendly evidence. Hostile evidence means brought witness to give evidence in his favor, but he changed his mind and gave adverse evidence. That adverse person who gave adverse evidence is called hostile evidence. Hostile evidence or adverse evidence, that is there. So when the impeaching credit of evidence means when a person friendly witness we turned it into hostile witness, then the alternative arrangement, the party will be given an alternative arrangement to give evidence, setting aside the evidence given by the hostile evidence. So these are the some issues are there. And next one is examination of last chapter is 10th chapter is examination of witnesses. Examination of witness in the sense section 135, 120, 166 Indian Evidence Act, 142, 160, 168 is New Evidence Act, New Bharatiya Sakshya Adhiniyam 2023. So here also examination of witnesses, examination in chief or chief examination, cross-examination, cross-examination, re-examination. Examination in chief means the plaintiff brings his witnesses, plaintiff lawyer questioning the witnesses is called examination in chief or chief examination. Similarly, defendant brings his witnesses, questioning his own witnesses, is examination is chief. Similarly, prosecution side witnesses, prosecutor question, that is examination in chief. Like this, defendant side, that is the accused side, defense lawyer, witnesses, questions his own witnesses, that is examination. If opposite party question, that is cross-examination. If plaintiff side witnesses are questioned by defendant's lawyer, it is cross-examination. After cross-examination is over, again plaintiff lawyer questions the plaintiff witnesses, that is re-examination. Again opposite party comes, it is called re-examination. In chief examination, re-examination, leading questions should not be asked. In cross-examination, they may be asked. Leading question means the question itself gives clue to answer. The question itself gives clue to answer. Leading question should not be asked in examination in chief or re-examination. However, it may be asked in cross-examination. Leading question. Then here examination, chief examiner, caution. There are some other specialized privileged communication. Whatever is communicated between wife and husband enjoys some privilege. There are some exceptions. Whatever is communicated between advocate and client is qualified, enjoys qualified privilege. There are some exceptions. So there are some privileged people, those admission when they can be admitted, when cannot be admitted, all these things we can tell. With this, almost 10 chapters is over. Last chapter is 11th chapter. 11th chapter contains only one section, that is 167. This is with reference to rejection. This last section refers to improper admission and reduction of evidence. Suppose there are some days improper admissions may take place. To admit a particular suit or proceeding, it should be admitted properly. Sometimes improperly it is admitted and dismissed, and sometimes a suit filed is rejected. So some go rather there. Sometimes proper suits may be improperly treated and rejected, or rejected on certain issues. Certain cases may be rejected unnecessarily by overlook. When once they are rejected earlier, admitted improperly, if they are filed fresh again before a competent court, because of the reason that it was previously already improperly admitted, cannot be accepted again, should not, the judge should not say it was already rejected earlier, it did not be entertained earlier, the court cannot say, but as fresh, it can be treated fresh, whether it can be admitted if everything is improper, or if it was, whether it was rejected by mistake, then it can be accepted. These things should be taken into consideration and be done. This issue is studied under section 167 in Indian Evidence Act. The same is repeated under section 169 in new act. In new act, chapter 12 is open for repealing and savings. In this section 170 is there for repealing of the certain acts. So these excuse, dear student friend, with this I have given you some idea about all this evidence law in brief. Please note that my classes are lengthy unless I take, because this only summary only lengthy time we will take, because previously I took 2 classes, but instead of taking 2 classes, if I put it in one way, you upload it, you download it in 5 to 10 minutes, whenever you are free you can be. If it is split into so many sections, 4 or 5 parts, you won't be able to do it, because I am taking very big project. If you cooperate like this, really I tell you, it is not possible to get shortest time. Whether I am able to teach well or not, it is you are the judge. Whether I am able to do well or not, it is your judge. But I am sincerely doing lot of hard work. If you to hear 1 hour you feel lot of difficulty, to prepare I have to work so many hours for your benefit, so many hours for your benefit. Please, if you make use of this and share it to so many of your friends, if member of students are okay, so don't think that I have given so many subjects lectures are there, you can make use of it. It is now I have started in elaborately I will teach, but for tentatively IPC, CRPC, evidence, law, and what are subjects, some nearly 10 to 12 subjects which I uploaded will be useful to you. Then you can develop it. In the meantime, till the examination come, I will cover all the topics. Earlier I gave lectures limited to meet the requirement of LLB student. Now I will meet the requirement of judicial service people and all. Please acknowledge my service and cooperate me. If with your inspiration only I will be able to do more and more videos. Please note that I will work as if I am one of the candidate appearing for judicial service examination, and I want to seek your cooperation. Tell me your requirements through your comments, so that I will do my best further.